Good morning, sir.
Please introduce yourself.
First, you have to unlock your device.
Please introduce
So,
yourself.
I have done my schooling from Odisha and Jharkhand both, and thereafter I had a brain surgery. I had brain hemorrhage because of which my left side got paralyzed, so I could not give my exam in the year my 10th board exam in the year 2006. I was supposed to give that, so I gave it in the year 2007, and thereafter in the year 2009 I gave my 12th board exams, and immediately after that I qualified the CLAT exams, and my AIR ranking was second in the PWD category, and I was allotted Dr. Ram Manohar Lohia National Law University. And sir, after that my treatment went on regarding this physiotherapy and other rehabilitation things, so I could not go for internships and other things. Then, sir, in the year 2019, I did my post graduation from Gujarat National Law University after qualifying the CLAT exams, and I was my AIR ranking was 17 in the PWD category. And then,
What
sir,
was
I'm
your
here.
subject in LLM examination?
Sir, my subject was Constitution and Administrative Law.
At present, what you are doing? Simply you are only staying in
So
your
I
house.
have taken admission. No, sir, I have taken my admission in PhD because, sir, practicing was difficult for me. I went to court, but physically, as I am not that much capable, physically that much not fit enough, so I felt like going for PhD. So I registered myself in PhD.
Do you think that you are now physically fit to discharge job as a judicial officer?
Yes, sir. I am physically fit for any kind of desk job, but in court practice, like I'm not that much incapable, like I cannot move or something. But there is so much rush and hue and cry in the court, like climbing upstairs and then coming back. So sometimes I might get pushed by someone or I might fall down. Some such things may happen. That is why I avoided that.
What is delegatory legislation? You are aware of it? Certainly, what is delegatory
Yeah.
legislation?
Yes, sir. So actually, the lawmaking power is with the legislative authorities. So when this lawmaking power is delegated, meaning thereby is transferred to the subordinate authorities like the executives for some time being for the basic, like for example, if there is some traffic disturbances or like recently there was COVID. So for the mask related guidelines, so such guidelines do not need legislative interference. So such power is transferred to the delegated to the subordinate authorities like the district collector and the executives, so that they can
What
make
is the
instant.
necessity for the delegated legislation?
So the necessity is that if we pass a law in the parliament, so it takes lot of time. It needs to be passed in both the houses, and then it takes lots of time then to assent from the president to become a law. So for any immediate action, if we want law, so we do not have such procedure at that particular time. So for immediate emergency situations, we give this power, and this is flexible enough, not bound by any procedure, but then it has to be as per the spirit of the law, not discretionary, anything arbitrary.
Probably you are from the state of Jharkhand.
So
Or
actually, I'm from the state of Haryana. I'm not also from
Haryana.
Jharkhand, but my mother is in the same judiciary, in the same field. So she's posted in Jharkhand. So that's why I'm here today.
Are you aware with the terms of the Odia terms? Are you fully aware about the Odia terms?
Yes, sir. So I did my schooling from Rourkela, Pragati Public School. So I was still my class standard 8th. I was in Odisha only. In fact, sir, when I was fit enough, I used to participate and I learned Odissi dance, and I was completely into it. So my entire childhood is in Odisha. So I like that place.
You can understand Odia language, even
Yeah, yeah,
Sambhalpuri
yeah. I
language.
can talk also. Yes, I can talk also in Odia. And
Also,
that's how I cleared the exam also.
Sambalpuri language also, probably when
Sambalpuri,
you were Rautala.
sir, I know Sambalpuri dance, but I don't
What
know
is
the language.
Badbhagi? What is Badbhagi? As per Badbhagi.
But- no, sir, no idea. So, is it
Badbhagi
related
also.
to something? Hanji, sir?
Hmm. In Sambalpuri, they use a term Badbhagi. Badbhagi Dinam.
No, no,
I
no
will,
idea, sir.
I will,
I know
I-
basic Odia, like I can talk to you like hello sir, kemti ochanti, or koti jautanti, something like that. I know the
you
basic
see,
language.
suppose you are a judicial officer in Odisha. Most of the
Yes, sir.
witnesses will come from this rural background. They have also this, they will also depose in Odia. How can you manage it?
No, no, sir, you can talk to me in general. They will talk about the day-to-day things that I can very easily understand. And in case, even if there is some possibility, some words like what you said, which I am not able to understand, I'll definitely learn them. There is nothing which nobody can do it, and I can learn it.
Okay. What is an offense?
Offense.
How do you understand offense?
So, according to the as defined in IPC or as in general, you are asking me.
You, I am asking you what is offense. I am not putting any
So,
definition.
offense, if I go by the general term, offense is something if you are violating any rights of any individual, or if you are affecting a public at large. It is offense is something which is against the entire state. Sorry, if you are violating any of the rights of other individual, which is leading to a public offense, like it is affecting a public at large, then it leads to an offense. But according to the definition of IPC, if any offense which is punishable with more than 6 months of punishment is there, then that would be termed as offense. But for example, like in traffic police, in those cases, challan and all those cases, that does not comes under the category of offense, because it is the punishment is less than 6 months in that.
Where it has been mentioned? Whether
Sir,
you are saying from your own understanding or own guess, or where it has been mentioned, if a particular act is not punishable with 6 months,
so
less
that
than
is
6 months,
mentioned
that
in
will
the
not be treated as
definition,
an offense.
sir, in
Where?
the
Which
definition clause
definition?
IPC.
IPC?
Yes, sir.
Probably you have forgotten. Probably any act or omission punishable by law is an offense.
Okay,
It may
sir.
be anything. Even 290 IPC, it is punishable with a very fine only. Even section 510, it is also punishable with 24 hours, 10 rupees.
Yes, sir.
It is
Yes,
an
sir. You are
offense.
right. Yes, sir. Yes, sir.
Okay, thank you. What is robbery?
Okay, sir. Robbery, robbery is robbery is when there is an instant fear of death, and a person causes that instant fear of death, and because of that instant fear of death, he makes the other person deliver some valuable property or anything which holds some value in the eyes of law, because of that instant immediate fear of death, and it is defined under section 390 of IPC.
What is abduction and what is kidnapping?
Sir, abduction is inducing someone and taking that person away without his consent, and in kidnapping it is of only of a child, and abduction can be of any person. He may be a child, he may be an adult, and in kidnapping it is, sir, enticing and inducing someone who is a minor from the lawful guardianship of his parents. And sir, it is defined under section 361 of IPC. And sir, in that law, in taking that person from the lawful guardianship, that person is using enticement and inducement.
What is
Yes, sir.
mischief? What is
Mischief is,
mischief?
sir, destroying or destructing anyone's property which diminishes its value, and it is defined under section 425 of Indian Penal Code.
Whether there were three optional laws in this judicial service exams in Odisha. Whatever
Yes,
were
sir.
optional subjects.
So family law and contract.
Family law contract. X is the husband and Y is the wife. They are married under the Hindu law. They have no child. X is simply making accusation repeatedly against Y that you are a barren lady. If on this ground there will be a divorce,
Sir, I didn't get your question, so please come again.
X simply made aspersion or called that wife, you are a barren woman.
Okay, okay, barren
Again and
woman.
again, it's a barren woman. You are not having
Okay,
a child. You are unable to procure a child or to bear a
okay,
child.
sir.
If
Hmm.
on this ground the wife can file a suit for divorce,
Sir, this would come under the ambit of the cruelty, which is not yet defined. So, sir, in the recent earlier, this definition of cruelty was limited to physical cruelty. Now, this definition is expanding by the Honorable Supreme Court's judgment, in which the definition of cruelty has reached till the extent of mental cruelty. Now, if these words which he is speaking to her, like you are barren lady and this and that, if that is hurting her till that limit that she's committing some mischievous activity, like if she is till the extent of committing suicide, like if you say these words in a single day, that would hardly matter. But if you repeatedly say these words to a lady, that this may amount to cruelty. So that is a ground of divorce that might fall if that is still that limit that leads to that commit suicide, that will amount to a ground of divorce.
when a divorced male person can marry,
Sir, after the period of appeal is over, there is a period of appeal of 90 days in the Hindu Marriage Act. So when that period is over, then that man and woman both can marry under the Hindu law,
then so
remarry.
far as in the Mohammedan law, when a divorced woman can marry,
Divorced woman.
hmm.
Sir, a
Under
divorced
Mohammedan law,
woman. Sir?
under Mohammedan law, if a
Yes, yes,
Mohammedan
yes.
woman, when she can marry after divorce,
So in Mohammedan law, there is a period of iddat, that is the period of purity. So it is believed that if that woman has conceived, then to make sure that who the child belongs to which father. So for that there is a period of iddat. So she has to undergo a period of, in general cases, 3 months. After that, she can remarry.
in all cases the period, either period is 3 months.
No, sir. If the husband is dead, then it is 4 months, 10 days. She has to undergo that much of the period. And in general cases, it is 3 months.
What is divorce by mutual consent?
Sir, so this is in a great in trend these days, divorce by mutual consent. Uh, so in the Shilpa Shailesh versus Varun Srinivasan recent judgment of Honorable Supreme Court, by using the power of Article 142, Honorable Supreme Court has said that by mutual consent, divorce may mean that both the parties are not ready to stay together, and they are mutually ready to sign an agreement that we are ready to and they have their own terms and conditions. Accordingly, they sign there, we are ready to separate, and there is no necessity of any specific grounds which are mentioned under the Hindu Marriage Act to be followed. So they can get separated on this mutual agreement. So now, sir, there was a waiving of period. So in this judgment, Honorable Supreme Court has said that this waiving of period of 6 months, that is the cooling off period, can be waived off if they are not ready to stay together in a marriage. Earlier, they had to go through this 6 months period. Now this can be waived off.
What is your view regarding divorce in under Hindu law? Previously, divorce was unknown to Hindu law. We
Yes, sir.
introduced
Sir,
divorce. Whether
yes.
it has made any benefit to the Hindu woman.
Okay, sir. So, divorce law, even we do not have any term of divorce in Hindi. Like there is a word talaq that is English because Hindu law never recognized this concept. It is considered as a pious sacrament. The marriage is considered as a pious sacrament, and the it is a relation of 7 years. It is believed, and so there is a no concept of divorce. But later on, it was believed. It was introduced, and then, sir, this concept, according to my view, it has got both its pros and cons, sir. Because if we force a couple to stay in a marriage where it is irresistible for both of them, they cannot survive under a single roof. Every day they are fighting and doing this and other stuffs, and it is leading to death of a lady, or maybe the male side is also getting harassed day and night every day. So it is better to introduce this concept of divorce. So according to
What is
me,
dowry
it
death?
is.
What is dowry death?
Sir, dowry death is a concept defined under Sir 304B. So, if any kind of cruelty to the limbs, body, or mind is done, and within 7 years of marriage, that lady dies due to this kind of injury, then it is believed, it is presumed, it is a presumption that she has died out of that cruelty done by her uh, husband and relatives of her husband.
Oh. What is decree
So,
according to civil procedure code?
so,
What is
so,
decree according to the
so
civil procedure code?
yes, so decree is defined under section 2, subclause 2 of Civil Procedure Code, which means an adjudication of a court which substantially determines the rights of the parties. So that is a decree
What
which
is
determines.
substantially? What do you mean by
So,
substantially?
so the word substantial means that those rights which are recognized by the civil law, which are the rights of other person, which you are also getting. But when you are getting a right, you have the duty to respect the other person's right. So that which are recognized by the civil laws, those rights are the substantial civil rights. If those rights are getting violated by some person, so that is adjudicated by the court.
What is deemed decree?
So, deemed decree is not exactly a decree because on those decrees, no specific right is decided, like restitution and rejection of plaint. So, the dispute is not on the merits, uh, it is deemed like a decree. It is not exactly a decree because it is on the preliminary issues. The decree is rejected itself, but it is a deemed decree. It is not exactly a decree, it is like a decree.
What is revision under the civil procedure code?
Okay, sir. So, sir, section 113, 115. Section 114, 15 talks about the revision. This is only before the Honorable High Court revision application is filed. So, sir, in this revision application, if there is no provision of appeal, or if there is a provision of appeal and appeal is not preferred, in those cases, revision can be filed. And, sir, revision can be filed when there is new evidence is discovered, any new evidence is discovered at a later stage, or sir, any other substantial fact is discovered at a later stage, so it can be filed before the Honorable Supreme Court, Honorable High Court, the application for revision.
Before Supreme Court, such a revision is there.
So no, it's before the High Court.
Then what is review?
Sir, review is filed before the same court which passed the judgment. So, sir, review is sir, I'm getting bit confused. Sorry. So just give me 1 minute.
Okay.
So just so just give me 1 minute. I know this thing, but thoda sa facts I have to recollect. So jurisdictional point. So sorry, I said something wrong, I think so, regarding revision. Sir, revision is about jurisdictional point. Right,
Okay,
sir?
okay,
So,
okay.
like, if we,
Don't be
if
perturbed. Be comfortable. Be comfortable. Don't worry. It's a monk interview. Don't worry. What is that?
yes, I
Everybody
know,
is
but
not
when I,
expected to know. Nobody is expected that he knows everything. Even I am not expected that I know everything.
sir, I
No,
said something wrong. Sorry, sir. I
oh,
think
oh.
revision is on the point of jurisdiction. If if some court is not working within the purview of their jurisdiction, then that is secondly, if it is going beyond its jurisdiction, and thirdly, if there is some irregularity, that
What is
case would fall.
confession? Okay, what is confession?
The confession is giving such statement. It is a kind of admission in which the person himself incriminates in himself, matlab in his own statement he incriminates himself. That is confession, and it is defined nowhere, but it is a type of admission. So that in that statement the person incriminates himself, or it should be such statement which should constitute all the offense, all the ingredients of the offense, and it should incriminate himself.
A confession, a person while in police custody is not admissible. That is the law.
Yes, sir. Yes,
You
sir.
see, ex an accused, he was taken by a constable to suppose a hospital for his medical examination. The constable was outside the hospital, and there the accused confessed that he had committed murder of Mr. Z. Whether that is admissible in evidence. The doctor
Sir,
says that is
yes, sir. Sir, प्लीज
okay.
कंटिन्यू, आप क्या पूछ रहे थे, प्लीज सर.
Um, X is the accused. He was
Yes, sir.
taken to a hospital for treatment by the police constable, and the police constable was outside the hospital. There in a room while X was undergoing treatment, he confessed that he committed murder of Z to the
Yes, sir.
police, to the
Yes, sir.
doctor. Whether that confession is admissible.
Okay, sir. So in this case, he is still in the constructive custody of the police. Since the police is standing outside, he has the fear, even if he is not present there, but he is in constructive custody. And therefore, that confession would not be relevant, according to what I think. Yes, sir.
Okay, thank you. I will give you the feedback regarding your interview after the second your interview by the second panelist. Thank you.
Thank you so much, sir.
Okay.
Uh, uh, good afternoon. Please tell
Good
me,
afternoon.
please tell me the recent judgment about right to privacy.
Sir, PS something Puttaswamy. Yes, sir. So the judgment was Puttaswamy judgment.
What does it say?
So that every person has his right to life and liberty, and his right must be protected, and he has the right to privacy, and so it should be protected under that.
There are two exceptions to the right to privacy given under Puttaswamy. Can you tell me what are they?
No, so I can't recall.
Okay, okay. What is the evidentiary value of an accused statement?
Accused statement. So accused statement is used for the purpose of contradictions, and in practical use, we can also use it for the purpose of corroboration also with the FIR and other statements given. But as according to the book, it is for contradiction purpose.
Okay, what is the difference between full blood, half blood, and uterine blood?
Okay, so full blood. So full blood is the blood. Our real brothers and sisters are full blood with the same mother and with the same father. That is full blood. And so when the mother is same and the father is not same, that is uterine blood. And half blood is when the father is same and the mother is not same.
And uterine?
Uterine, I said, so mother is same and the father is not same.
Right. Who is a Mutavali?
Mutawali is, I can't recall, so sorry.
Okay. Can you tell me the difference between rectification and recession under specific relief act?
So it was not my subject, sorry, I haven't done this. It was not in my optional.
Okay. Okay. Tell me, B makes a gift to X, Y, and Z. Okay. While X and Y accept the same, Z refuses it. What happens to the gift?
It
The
would
three
not be
persons.
valid for. Sir, I did not had TPA also, but still I can answer that it would be valid till that extent to both of them who have accepted that gift, and who does not accept that person for that the gift would not be valid.
Okay. What is the relation between section 300 and article 20 clause 2 of constitutions? Section 300 of CRPC and article 22 of constitution.
So Article 20, subclause 2 of Constitution talks about double jeopardy, and Section 300 also talks about auriferous convict and auriferous acquit. That means that once a person who is convicted for certain offense should not be harassed twice for the same offense, and that thing should not be tried even and not convicted for the same offense if he has been tried for one offense once.
Okay, okay. Whether a charge may be framed in a warrant case only, or it can be framed in warrant case and summons case both.
Sir, a charge can be framed only in warrant case and not in any summon case, because the summon case, the proceedings are very summarily tried, and the substance of the there is a substance of acquisition in those cases and not the charge. But it is not, it is, there is no charge in summon and summary trial,
So
and
you're
there is
saying,
substance of
so you're
issue.
saying in summons case, charge cannot be framed at all.
It is not framed in generally, practically it is not done that, because we have to finish the trial in summarily.
Okay, okay. Uh, can res judicata apply to bails?
Res judicata apply to bail cases.
As in the principle of res judicata, not res judicata per se.
So in bail cases, the grounds of the bail, if they are changing, then that principle will not apply. If the grounds are same, then that principle will apply.
Okay. Whether a complaint can be made orally?
Yes, a complaint can be made orally, but it is generally in written form. Complaint needs to be written and drafted and produced before the court.
Okay. And can an FIR be termed as a substantive evidence?
Sir, FIR is not a substantive piece of evidence, it is a corroborative piece of evidence. And on the sole basis of FIR, there can be no conviction.
Okay. Okay. Uh, what is the difference between dismissal for default and ex parte?
Dismissal of default is when the party is not coming in the court, especially the dismissal in default is when the defendant on the producing the summon on receiving the summon, he is not coming to the court. In that case, the court will dismiss, that is dismissal on default, and that is not on the merits. And the second thing, sir, what you asked me?
Ex parte.
Ex parte is um, when the that defendant is not coming before the court on even after on receiving the summon. So then the court will grant this ex parte order. Then this
Okay.
can be set aside under Order 1 Rule 30.
Okay. Okay. Uh, my last question is, can you tell me the difference between a code and an act?
Sir, I know about act that when a bill is which when a bill receives its assent from the president, it becomes an act. But
That too we
then
know,
when
act and bill. I am asking act and code. Why
yes,
is it
yes,
that
yes,
Evidence
yes,
Act and Indian Penal Code or Criminal Procedure Code? Why?
yes, sir, that is what I'm thinking. Why it is called a code? Um, sir, sir, I'm not sure about this. Sorry.
Okay. Okay. Thank you. Thank you. We can proceed to the feedback.
Okay, sir.
Okay, Nishtha, I put while introducing yourself, never
Yes, sir.
tell your problems. You are fit enough. You think that I am fit enough.
Okay, sir.
Always,
Sir, actually,
okay.
there is time gap. That's why they
What
might
is
ask.
that? I did not ask you to know why there is a age gap, why is it such a your age or in
Okay,
the late age you are appearing. My
okay, sir.
question is, you introduce yourself. What will be your
Okay,
introduction? I am so and so. I am from this place. And my qualification, education qualification is this. And presently I am doing this.
okay,
Small.
sir.
Okay. Never, because never, yes, everybody has problem. That is my
Yes, sir.
problem. That's your problem.
Yes, sir.
With
Yeah,
that
that's
problem,
right.
you are appearing in examination. That should be encouraged. Encourage. Never draw because my problem. Everybody has a problem. That's a
Yes, sir.
life is full of problems. There may be physical problem. There is every problem. That is problem. Some problem you have to keep in your mind. That should
Yes,
be
sir.
suppressed. Okay. Because thereby you because creates a problem, then the examiner may think that he may not be fit for the job. Never do this. Okay.
Okay, sir.
Okay. Delegated legislation. I put a question. What is delegated legislation? Yes, you know, because you are doing that subject LLM, you have enough idea. That is enough knowledge, much knowledge on that delegate legislation. The answer because I have a limited knowledge. What is that? Because everybody that all laws that we passed by the parliament or legislative assembly. Our parliament and legislative assembly are so burdened, they cannot find time to make detailed provision for implementation of the act. So that is why some power is delegated to the subordinate, that is executive head, to make rule making power. That is called delegated because of necessity, not emergency, because of necessity. Every rule is to be passed by the parliament. No time, very precious time, valuable time of the parliament. So that is why this delegated, because delegated legislation rule will never override the act passed by the parliament. I will repeat it. Udia term, I put a question. You are outside our state, and your answer should be yes. I know. I had a Udia background. I am staying in Odisha. I know I understand Odia language. I can write Odia language. And if a particular Odia term is there, I will ascertain it by meaning with the help of the advocate appearing for the party. You will help me because he is an officer of the court. You can understand. That will be question. Offense I told you. Rights and public offense. No, public offense is not there. I never. What do you understand? I put a question. What is offense? You should. What is your concept? What is your idea? What is an offense? Any act or omission punished by law for the time in force. That is an offense. Not 6 months, for 1 month, 2 months, 1 rupee, 2 rupee. Any act or omission which is punishable of law for the time in force, or In this IPC, there is a provision, any act for which a complaint can be made under section 20 of the Constitution. There are two offenses. Right? Your answer is that like this. The robbery. The robbery also, your concept is also not clear. Robbery, a theft becomes robbery and extortion becomes in certain sense. While committing theft or in attempt carrying out the property of theft, the offender for that and causes any hurt, grievous or injury, etc., then that becomes robbery. Similarly, while extortion, instant fear of death, etc., is called, that is robbery. That you know. Abduction and kidnapping also, your concept is also not clear. You should never, if it's kidnapping, maybe kidnapping from India and kidnapping from lawful two kidnappings. Lawful guardianship, minor, insane person, idiot, who takes any person or entices. Takes, entices, two words are there used without the consent of the guardian. That is kidnapping from lawful guardianship. Kidnapping from India means whoever takes any person beyond India. That is kidnapping from. Abduction, any person by force, by deceit. That is not itself an offense. By any force or deceitful takes any person from one place to another. That is abduction. That is abduction. A minor, major, anybody abduct. Then mischief, whoever intend with an intention or knowingly that he will cause any damage or destruction any property of the public or any person. That is mischief. Destruction or damage to property of another or of the public. Intention is there. That is mischief. Then, yes, I put a question making allegation that a barren lady, that itself a cruelty. Not necessity, you should say that's a cruelty. Cruelty is not defined. I mean mental cruelty. If a person is, there is an aspersion against a woman that she is a barren, not on one occasion, but repeatedly, that will definitely be treated as mental cruelty. On that ground, the woman can seek divorce. Then, divorced male person can marry Hindu. A divorced male Hindu can marry. After divorce, after expiry of the period of limitation for appeal, or if appeal is before, then after the appeal is disposed of. Finally decided. Similarly, a Mohammedan woman can marry. After Iddat period, you are correct also. And Iddat period is 4 months and 10 days in case of death. And in other cases, 3 lunar months, the menstruation woman, not in 3 months. And if she is bearing child till that delivery child, then thereafter she can marry. Divorce by mutual consent, I surprised that your concept is not clear. Divorce mutual consent, if both husband and wife are living separately for 1 year and more, and they are unable to live together, and they have mutually agreed that to dissolve their marriage by divorce, then they can file a petition to get divorce as per the provisions of section 13B of the. You are clear. Cooling period is 6 months. That is there. Not that can be waived. I did not put that question. Then what is divorce by mutual consent? They are living separately for 1 year and more. They are mutually agreed, and they are unable to live together, and the court satisfied. Then this divorce by mutual consent will be. This is the concept. Then dowry death, you also again fail. Dowry death means if a death of a woman takes place within 7 years of her marriage, and it is shown or proved that soon before her death, she was subject to cruelty for dowry by or any of the relatives, then that will be treated as dowry. Probably you are clear. Decree. Substantial. Decree means a formal expression of an adjudication, which so far as the court expressing it, which determines all the rights and due to controversy, all the rights which are in controversy in this conclusively determines rights in controversy in this. Then deemed decree, if decree rejection of late and any matter regarding restitution of property after the decree is reversed. That is this. Revision and review, you are a little bit confused. Review after passing of the judgment in the same court without preferring, even if appeal is allowed, without preferring appeal, the party may file petition for review of the judgment. If the interviewer doesn't expect that you will be very answer it everything, at least you have the idea the review of the judgment in the same court without preferring appeal, without preferring appeal, even if when the appeal is not allowed. Yes, the review of the judgment. New materials is discovered, new evidence is discovered, or any other sufficient reasons. Revision means the High Court or the district whose civil power call for the record which failed to exercise jurisdiction, exceeded jurisdiction. On that ground, jurisdiction ground, that revision is made. Then confession. Confession is a statement when a person admits guilty of committing an offense. That is confession. Yes. When in police custody, confession is not needed because when a person is taken, an accused is taken to the medical for his medical examination, and the police is outside, then still is in police custody, not constructive, is in police custody. Whatever, when custody in police, if confession is given, that is what admissible in evidence. Then another tips I want to give you: never make your answers lengthy.
Yes, sir.
Okay, try to confine that you is abridge your answer, short your answer. More answer, more talking will simply will attract more problem for you.
Yes,
What the
sir.
examiner is putting, you try it. Thank you.
Thank you, sir. Thank you so much.